Nath, you reached before me.
Oh, Gary.
I saw you waiting for your turn, huh? Impatiently before the DV. The tiredness in your face for saying it all. Anyway, it's very difficult when then you don't know at what time your matters will be taken up. Yes, no problem. Where are your arguments?
Yeah.
Well, I thought I asked him yesterday, has anybody given any argument? He said no. Today morning again I asked. I was in the impression you'd be giving it in advance, then I thought I will make an attempt now. But anyway, you give it to now, I'll fix another date. Let me go through the arguments.
And the two agreement translated.
Are you now? I think you'll have to give me back your case laws also, na? I think I returned everything, right? Huh?
I have already.
এটা কাম কৰা দুটা ডাঙৰ ব্লাইণ্ডাৰ্ছ ক্লিপ লোৱা কমল ব্লাইণ্ডাৰ্ছ ক্লিপ দি মাৰি দিয়া হা you sort out Mr. Datta, sort out your papers properly. I'll give you time. You don't have to hurriedly give it because your papers I saw had just fallen down. You sort it out properly and give it.
Another vital aspect I forgot to bring to your lordship's notice that day, their written statement. If your lordship comes to the written statement,
I'm not closing it right now.
just I want to bring this up, that in the written statement they have specifically admitted everything. Whatever we have stated in your brain, they have neither specifically denied it nor they have admitted it. That means that amounts to an admission in terms of order 8.
All right.
So,
statements not denied. They have not denied to which part of your statement?
Paragraph 4 to 18 of her.
What is the sum and substance of those paragraphs? Just say me.
The facts that they have received this sum.
The compensation.
Compensation.
They have not received.
No, not regarding compensation. They regarding advance amount.
The advance. That 31 lakhs up to 21, 12, 18.
So that is admitted.
That's an admitted position. They have not denied.
So
in fact, that subsequent agreement was to that effect.
Yes.
They will return it.
Yes.
And if they returns it on a particular date, then everything. And if they don't, then that is was the second agreement, isn't it?
It is fortified.
That's an admitted position. I think
position.
facts, there is no difficulty.
Fact, there is
By and large, facts are all admitted. Now only whether because of the subsequent event, this entire agreement becomes infructuous.
Yes.
This is, I think, what is the issue, no, Mr. Ghosh?
That is why I initially that.
Anyway, let me read it and then let us have it on another date.
I have given along with the
The case laws.
Case laws, and I
list.
This,
No, এবার আমাকে দেখাই দিও। What is this agreement? Oh, this is a translated agreement. Okay. I think this is the second agreement, no? Both translated. So 15.2 is the second.
15.2 is the second. 2 first. 2 to 17.
Exhibit 20. It is in.
Have you given copy of the translation to Mr. Datta? You have a look at it, Mr. Datta, because these are translated copies.
We have also translated and submitted.
I don't want to be subjected to two different translated copies of the same agreement. Please give me one. You both exchange amongst yourself and give me one. You do one thing. You have a look at these two also.
Yeah, I have given.
And then give me.
My lord, I
have the copies.
You have the copies.
Yes.
Have a look at it. If there is anything, then you point it out to the court master or on the next date.
Yes.
Heard Mr. So-and-so, सबको area. Parties in terms of the earlier order dated so-and-so have submitted their respective written arguments and the list of decisions in support thereof. Relist on such and such dates for further hearing. I am mentioning it as further hearing. Most likely you will have the typed, edited version of the draft on that day. Let's see the date detail. I'm not going to be here for which week? From 7th. তুমি কেতিয়া আইজল কেতিয়া লিখা আছে 7th ৰ পৰা মানডে নল'ব মানডে ভোপাল আছে ন টিউজডে কৰি দিয়ক 17th okay anything you have some difficulty
No problem. No.
if there is any difficulty let me know but most likely nothing will happen on that date I'm just not fixing it because then it becomes difficult in case I need more clarification so after I read the judgments everything is okay then on that day you will get your judgment okay
Obliged.
yes could you find anything because I'm stuck only on there
I think I think my lord. I think because I made a lot of search.
Did you get Justice B.K. Sharma's judgment? I got it.
Lordship has got it, this one.
I got it. But this also doesn't help you because it says that I've considered the submissions made by the Learned Counsel for the parties. I've also considered the entire materials on record.
No, yeah, extra.
Mr. Nath?
Yes.
In the aforesaid two decisions, it has been held that if the management does not want to rely upon the domestic inquiry, it is entitled to lead evidence in the proceeding before the tribunal. It has also been held that in the case of any finding to the effect that a domestic inquiry was not properly held, the tribunal and or the labor court is normally required to provide opportunity of adducing evidence towards sustaining the charge that was earlier leveled against the workmen.
Right.
In the instant case, it was the specific case of the management that in any event of holding the domestic inquiry not legally valid, it should be allowed to adduce evidence in support of the charge that was leveled against the workmen. So on that, the court says, in view of the above, the impugned award is set aside to the extent of allowing the management to adduce evidence towards sustaining the charge and similar to the workmen.
Yes.
Now here, there was a request in the written statement.
That's what.
But in your case, that
There's no
that is
request.
not there.
Now that's what.
Now, admittedly, now you see, I think we all are agreeable to one particular point that the tribunal, after once coming to a finding that the inquiry is not valid, cannot automatically reinstate.
No, cannot, no way.
That we are on the
The
same
judgment is
page.
also there. I've got
Yes,
judgment.
that no difficulty. This is what has been, held right from Iron Steel 1958.
Yes.
This is what it is, the consistent view of the apex court, right? Now the moment the court holds that the inquiry is not properly done, we know that the court cannot straight away go and reinstate. The court will have to examine. Now, in that situation, how will the court examine? There has to be something adduced on merits. If the management has already adduced evidence on merit at the initial stage, so has the workman done. There is no difficulty. After considering the validity, the labor court has to consider those merits, right?
Yes.
Or if the management have said that no, if this goes, we should be given our opportunity. Absolutely no problem. Then the labor court at fresh will give an opportunity to you both. That now that we have held, the inquiry is gone, everything, whatever happened in the inquiry is out of the records. That has gone away. Now you prove it in the labor court that dismissal or the termination is bad. Is proper for the management. So then the management brings witnesses to show that yes, so and so has done this, which is a misconduct, and that is why he needs to be given that punishment. This is how I understand it has to work. Now here, I was going through your evidence. I don't think there is any averment anywhere.
No, it's not there.
It is not there. So that is also an admitted position. But in your evidence, I find You have given evidence on merit.
Entire procedures, what happened in that
No,
proceeding.
procedure is the inquiry. That is related to the inquiry. But what about the charge? Is there any evidence on merit? Because why I'm asking you, Mr. Nath, if today I come to a conclusion that the inquiries, that the order of the labor court in reinstating is automatically reinstating is bad, then what do? I have to send it back.
But again, there is a,
Now, if I send it back, the labor court will do what? We'll have to hear on merit. Now, you have never exercised your option
that's what my,
of adducing evidence.
now,
Now, those 2-3 decisions of Supreme Court are very clear that suo moto, labor court or tribunal is not going to ask you to adduce evidence. It was your right, it was your duty to ask at the relevant time. At the relevant time, you have not asked. Now, since you have not asked, would it now preclude this court from resending the matter back to the labor court to give you that opportunity? Because the moment I do that, I am going to go against those 2-3 decisions of the apex court.
no prayer.
No prayer. Admitted position, no prayer. So that is why the other day, if you remember, I had asked your junior also to check your evidence. Now, because when I was reading your I was reading the labor court judgment, I came across few paragraphs which indicates that in your evidence you have also given evidence on merit. Now, suppose if it is there, then we can send it back and say, ki you now you adjudicate on merit.
Yes,
Otherwise, what is the point of sending it back?
yes, my lord. I understand.
There's nothing to do it.
Now my-
If you have not given evidence, you have not even requested to give evidence, then for what reason will I send it back? But at the same time, I mean, this of course was not perceived in the mind of the labor court at that time. They did not do it in the manner they should have done it. But sending back would be an useless formality in that situation. So I am in that point.
The way I'm thinking, my lord.
Yes, yes.
In this type of cases, workmen cases, once it goes to the labor court under section 10 or 22A. Now the Honorable Supreme Court also just issued some judgment, my lord. It says it is obligatory on the part of the labor court to draw preliminary inquiry, preliminary issue on this. Now here is this case, number one. Suppose in the preliminary issue is decided in favor of the management, chapter closes. If they say inquiry is perfect, there is no defect, chapter closes, my lord. That is what does.
I understood what you're trying to
Yes,
say,
yes.
Mr. Nath. But
Yes.
the problem again is because those 3 decisions of apex court has very elaborately
No,
said it
no.
that the management has a choice. Now, if
No,
you
this is second stage. Lordship is coming to
you
second
see-
stage. Second stage.
Mr. Nath, the problem is in your written statement you relied on the inquiry.
Yes.
So where is the question of going into all this? The labor court have heard you.
No, I'm just coming to it. That's what.
You see, now just because the labor court did not draw up a preliminary inquiry, can we say that is the reason the entire labor court judgment is bad and we send it
No,
back?
if the
Because if we send it back also, what will
No,
happen?
coming to it, my lord. Just
Yes,
give me
yes,
2
yes,
minutes.
yes, yes.
Ultimate time to solve the issue.
Yes, yes, yes. I
Now-
think what you're trying to say, I'm sorry, I'm reading
No,
your mind,
it's all right.
but I think what you're trying to say is that since the preliminary inquiry was not initiated, so you actually never had an opportunity to ask for this option. I think this is how you want to say it, perhaps.
Because apex court says this is obligatory on part of the code. It is not that we will make a pension. The code ought to have done this, my lord. This is my lord lordship will find in Nila Caprice also. And
Nita Kaplish and the Supreme Court decisions doesn't say that labor code is obligatory on its
it is
own.
there, my lord. It's there.
Because it says that labor court only when you ask.
No,
Suppose you don't want.
no, this is the second stage, my lord.
You-
That's why I
you-
say.
See,
Preliminary review is the second stage.
you see, Mr. Nat,
Hmm.
suppose you are not even relying. You give your evidence on merit. I have seen cases where the management is adducing from day one on merit. And at the end, they may add a one paragraph that we have done an inquiry and this is the inquiry.
My lord.
So there, in that situation, what happens? Before the labor court, there is evidence on merit. There is also the inquiry report. Both are there. Now, in that situation, what should the labor court do? The labor court in that situation will first see whether the inquiry held by the management is valid or not valid. If that goes, then the labor court will see the merits.
There is a second stage.
So that is why I'm repeatedly asking, have you given anything on merit? Have you checked your evidence, Mr. Bora?
My lord.
I think you have given on merit. Have you given?
Now, my lord, no, I have some gone through it, my lord. If I read the entire evidence, then I find a lordship is right, because we have said the entire things, how it was conducted, on merit. That part.
So that is what. So show me where it is.
My lord, no, my lord, I will coming to it.
Huh.
But what I am trying to say, just lordship take this judgment one,
See,
my lord.
then what you're submitting will come in,
Just have a
will
look.
perhaps have more relevance. Because then we can say that yes, it was obligatory for the labor court to first frame a preliminary issue.
My lord.
Because you have adduced evidence on merit as well as you have stated about your inquiry.
Let me
And what the labor court did, the labor court, instead of going into the merit, straight away held that no, the
reinstatement. Now
reinstatement.
let me say one thing, my lord.
Huh.
Just for let us see the picture. Now the labor court has said that it may not be fair inquiry. Assuming labor court said this is defective.
Right.
Now the day argument was made, my lord, the argument was made, final argument was made on 7/12/22. Judgment was passed on 13/12/22. On that day, the labor court said it is defective and reinstatement. Now, here the full judgment is passed. Now, if I read all this judgment, then I feel that once the labor court says this is defective, then the question comes on, if the court says today this is defective, then I'll make a prayer. All right, alternative prayer, my lord.
This submission of yours has been rejected by the apex court. Case law summary
My lord.
that has been rejected by the apex court. That's not the stage.
Lordship, may kindly see that judgment of 2023 of Justice Shuman Sharma, my lord.
That is that's a coordinate bench judgment.
Yes. It was
the
referred.
apex court judgment clearly says it.
Nita Kaplish, paragraph 20, my lord.
We
Nita
will
Kaplish.
see.
Nita Kaplish to? No, Nita Kaplish here.
No, I think I have the decisions of yours.
Yeah,
It is there. Don't multiply. Nita calculations here.
now it's a lordship day. Yes.
Otherwise, it becomes difficult.
Paragraph 22. Let us see.
Mr. Nath, we are, I think because this issue needs a clarification. So
My
if
lord.
we can do that, it will really help in future.
Yes. That's
Because there is a gap.
there is a gap.
There is a gap at
Now
this
I also
area.
feel your lordship now will remand back with no prayer. No, how to come over that?
Then how to do?
How to come over that, my lord?
We
Now,
need to-
now, my lord, suppose.
Because because what you are saying makes sense to me also, that you see, unless and until the labor court comes for finding that the inquiry is not valid, when does that stage comes for you to ask for that management? I also understand that perhaps the best course for the labor court would have been at that stage to give you an opportunity. If you say yes, I want to
My lord,
adduce.
in Karnataka case, it says, my lord, in paragraph, it says
Which
there's
one?
no fetters on the part of the. Let us see that Karnataka case, my lord.
Where?
My lord, Dipankar, listen.
I think another matter.
One bunch I have given now. Lordship, kindly see bunch. This is
Serial which number?
serial. I'm giving serial B. Serial B.
Yes.
Let us see serial B. Let us just check, my lord.
Yes.
Let us
Karnataka.
check Karnataka. Serial B is our, I think. No, serial B is, my lord, your lordship will find.
Justice
Rumapal, yes.
Yes.
Let us see in this paragraph 8, my lord. Let us see in paragraph 8. Paragraph 8, let me read. Because there also I got stuck up, my lord. Lordship has some right at that point. The appellant has challenged this decision of the High Court before us. We are of the view that order of the High Court dated 2nd December, as clarified on March 3, does not need any interference. It is true, no doubt, that the respondent may not have made any prayer for submitting additional evidence in its written statement. But as held by this court,
This will support you.
this one,
This Faraway, it will support you.
is no factors, it said.
It
That
says.
judgment I have got with me, Karnataka, my lord, because I'm trying to get a handle, my lord. How to-
This is definitely supporting you. It's a two-judged,
yes, yes.
two-bench.
Karnataka, let me get this one. I have got this judgment. I brought it, my lord.
I have it. Oh, the other one.
Karnataka.
Karnataka SRTC.
Yes.
Let us see that.
Yes, still not 7. Last of all. Here. My lord, no, it is not there, my lord. It's here. This is separate bunch.
How many branches you have
No,
prepared?
no. These are for first day. Subsequently brought out this, my lord. Lordship may keep aside that one. That's why I given today's one is ABCD, and kindly see this one, my lord. This is Karnataka. Fetters part. Lordship will see. Fetters, no fetters. There are 23, 41, 44. There are 23.
Larger bench, yes.
My lord, there are 23, my lord.
Para.
23. Para 23. It is consistently held and accepted that strict rules of evidence are not applicable to the proceedings before the labor court tribunal. But essentially, the rules of natural justice are to be observed in such proceedings. Labor court tribunals have power to call for any evidence at any stage of the proceedings if the facts and circumstances of the case demand the same to meet the ends of justice in a given situation. We reiterate that in order to avoid unnecessary delay in multitude proceedings, the management has to seek leave of the court tribunal in a written statement itself to read additional evidence to support its action in the alternative and without prejudice to its right and contentions. Next sentence. But this should not be understood as placing fetters on the powers of the court tribunal, requiring and directing parties to read additional evidence, including production of documents at any stage of the proceedings before they are concluded on, or if on facts and circumstances of the case it deemed and just necessary. I think this might give a handle to your lordship, my lord.
A bit of
Yes.
relief looks like is coming for you.
Because ultimately, my lordship, can see one thing. Fact is
That's
one
right.
thing, fact is one thing, and the law is one thing. Law always takes the upper hand, my lord. So here is the case where the trial court has committed a mistake by not doing preliminary inquiry. And instead it has got 3 stages, my lord. First is preliminary inquiry. If it goes against, if the court says that no, this is defective, the second stage is, my lord, court will see whether it is justified, dismiss is justified or not. Third stage, if the court finds that, my lord, that dismissal is illegal, then they got the proportionality of the minor punishment. Third stage, this is, my lord. Here the trial court is in one swing has finished everything. Preliminary inquiry, then merits of the case, then the reinstatement. That is proportional, whether it proportionate punishment or in one go. Table court has done this. So I say, my lord, the law always prevails, my lord. Maybe this is technicalities a bit, but that's why I think honorable court was aware about the situation might arise. So there is a fetters, my lord. That's the reason. And this has been, my lord, upheld, quoted by the honorable Justice Shumon Sammaldo in his judgment, my lord. Now serial A, lordship may kindly see. I have given this bunch now serial A in my today's bunch. In my today's bunch. Let us see my paragraph 22 and 23. These 2 paragraphs.
Number 8 too. Or number.
My lord.
1 second.
My
It is Britannica, no? Britannica 2026. Yes, you were saying something.
My lord, paragraph 22 and 23. Let us of this. My lord, Justice Shubhan some judgment, my lord. This is flag A of today's bunch.
Yes.
Actually, it has become too many number of judgments because I was trying to find out this, my lord, how to come over this problem. Ultimately, lordship had to decide this point, my lord. That's why, my lord.
Yes. Yes.
This is of 23, my lord.
Yes, I know about this case.
Paragraph 20. Lordship, these are all lordship.
No, yes, tell me paragraph.
Paragraph 22 and 23, my lord. This will.
Yes, please read.
My lord, let me read. Good. In another decision rendered in the case of Nita Kaplish, it has been held that in cases where inquiry has not been held or inquiry has been found to be defective, the labor court can call upon the employer to justify its action taken against the workman and show by fresh evidence that the order of termination or dismissal was proper. If the management fails to lead evidence by availing the opportunity granted by the court, then in that event, it cannot raise any grounds at any subsequent stage that it should have been given that opportunity, as that even in those circumstances would be justified in passing an award in favor of the workman. The observations made in paragraph 24-25 of the said decision are relevant. Paragraph 24. In view of the above, the legal position as emerges out is that in all cases where inquiry has not been found held or inquiry has been found to be defective, the tribunal can call upon the management or the employer to justify the action taken against the workman and to show by fresh evidence that the termination or dismissal order was proper. If the management does not lead evidence by availing the opportunity, it cannot raise any grounds at any subsequent stage, and it should have been given the opportunity, as the tribunal in those circumstances would be justified in passing an award in favor of the workman. If, however, the opportunity is availed of and the evidence is adduced by the management, the validity action taken by it has to be scrutinized and adjudicated on the basis of the fresh evidence. Second stage, this is. Now, paragraph 23, let us go by. Paragraph 23.
Yes.
The scope and ambit of jurisdiction of the court tribunal to interfere with an order of dismissal based on domestic inquiry came up for consideration in the case of ML Singla such and such. It was the case where department inquiries held against the employee, that is the appellant in that case, by serving charge sheet. An inquiry officer was appointed to inquire into the charges. Whereafter the inquiry officer had submitted its report. On the basis of the inquiry report, the appellant was dismissed from service. The appellant has approached the state government raising an industrial dispute, based on which a reference was registered before the labor court so as to decide on the question of legality and validity of the order of the dismissal from service. Based on the evidence adduced by the parties, the labor court had answered the reference such and such. Rate petition filed by the employer bank against the order of the labor court was allowed by the High Court by setting aside the order of the labor court. Dismissing the appeal filed by the employee against the order of the High Court, the following observations were made by the Supreme Court, such as the paragraph 15. This is important. Paragraph 15, my lord.
Yes.
First error was that it failed to decide the validity of the legality of the domestic inquiry. Since the dismissal order was based on domestic inquiry, it was obligatory on the part of the upon the labor court to first decide the question of preliminary issue as to whether domestic inquiry is legal and proper. My lord, can I pause for a moment here? Here, what I'm trying to say. On the day judgment was passed, entire case was closed in stating. Now, suppose today judgment was passed only on the legality of the bid, and the court holds today, all right, fixed in the date. Next date, suppose it did not come with a prayer. Here, there is no chance because the one day it was heard, and after 1 week, entire case was disposed of. Now, where is the scope for this person? That's why it was said it's obligatory. So that one date is fixed there. Next day, suppose court will not advise the client, my lord or the advocate. On the next date, see, I have decided this case against you. Date is fixed on such and such for ordinary orders. Next day, suppose the advocate for the party management does not come with a prayer, my lord. Obviously, he cannot open the chapter, my lord. That's what the meaning I feel, my lord. Next, my lord, paragraph 17. The answer to the question on preliminary issue was that the domestic inquiry is legal and proper. The next question to be considered by the labor court is whether punishment, my lord, this is the second stage and third stage. Now, my lord, paragraph 25. Paragraph 25, operative part, let us go to that side, my lord. From careful analysis of the aforesaid decision, what follows is that the decision of the management to terminate the services of an employee based on a domestic worry cannot be interfered by the labor code on mere ipse dixit. The labor code, he himself stated like, the labor court will have to first decide the preliminary issue. The question is to whether the domestic inquiry was fair and proper.
Yes, you read,
Proper, and the observance of the principle of natural justice. If the answer to the said issue is found to be negative, it is only then the question of adducing evidence of the employer and the employee would arise, so as to enable the court to pass an order in the merit of the reference based on the evidence such and such. If, however, the labor court does not find any infirmity in the proceeding, then the order of penalty can also be examined by this court. This is what it says. The 3 stages talks about. First stage, obligatory on the part of the labor court. They will decide, yes, this is inquiry is defective. Then they will hold, fix a date. Next day, suppose if I file an application, give me, we want to adduce evidence. All right, court can go into it and court will decide, they go to the merit of the case. Then the section 11A comes into picture, my lord, of the ID Act. There court will see whether the entire dismissal process has been followed or not. If the court finds that no, it has been followed, then court may dismiss that, my lord. Suppose court says no, this is wrong, then they'll not setting aside. Court will see this is illegal. Your decision taking for dismissal of the person is illegal. Next stage, if it is illegal, proportionality. Then the third stage comes. Here is the case where Lord, the first day entire thing has been given, my lord. The labor court says defective, labor court says inquiry is illegal, labor court says reinstatement. That's what I'm trying to say, my lord. So in terms of this two judgment, my lord, probably lordship has got the chance because ultimately the law should prevail, my lord. That's my submission, my lord. And my lord, about this stages, my lord, one judgment is very important here. Let me show, my lord.
So it is ultimately in this Karnataka case, the fresh chance was given.
Yes.
What happened ultimately here? What was
it was remanded back, my lord. Remanded back. 5 judges bench. This is Karnataka case of 5 judges bench.
So here, but in this, okay.
Karnataka case is of 1 minute. What would it be? What would it be?
I think Karnataka will be of help to you,
my lord,
because it's a 5-bench judgment.
And also,
and this the one which I was thinking was because of which I was not being able to give you that chance.
my lord,
This is that Britannia's case is of 3 judges.
3 judges, my lord.
Where clearly it says before this court, that part, no, that there will be no suo motu.
Oh, that is what, that's in that suo motu part is, my lord, lordship will find. It's there, my lord. Lordship will find in.
Because that is against you, no?
That is against me. That's against me.
Suo motu is against you.
But my lord,
but Karnataka is
5 judges bench.
5 judges bench,
Yes.
which appears also, if to you see, at the end of the day, if that's the principle that the labor court would first examine the validity of the inquiry, then it is logical that if the finding of the inquiry is not proper, then a chance to the both sides to prove it on merit.
Yes.
That is very logical.
Yes, my lord, another thing, my lord.
Now, just because one party did not ask,
technical, this is technical, but the law prevails.
Because in that situation, you will have no option but to reinstatement, because what else will you do?
Ultimately, law of the land will prevail, should prevail, my lord. I feel.
Because here the option is not given.
My lord, one interesting thing. And this take flexi, Firestone, flexi. Lordship will find one thing. Straight away, they cannot do all these things together. The trial court, it's there in Firestone. Flexi.
Which is this case?
This is Workman Firestone, my lord.
Larson and
73-1.
Ajay, this is Firestone.
Yes, kindly see. One interesting paragraph is there.
Oh, this is Firestone.
Yes.
Yes, Firestone is very famous.
Yes. Paragraph 27, please come, my lord.
Paragraph
27. That's in page number 14. Bottom. Page at the bottom.
20.
At the bottom.
1 second. Just a second. Paragraph
Paragraph 27, page number 14.
20.
Page is at the bottom, my lord. Page
Yes.
number, right side, 14.
Yes.
Now, 27, 4 kindly see, middle.
Yes. The principles.
Yes, principle, that's see 4. 27 bracket 4, bottom, in the middle. Even if no inquiry has been held by an employer, or if the inquiry held by him is found to be defective, the tribunal, in order to satisfy itself about the legality and validity of the order, had to give an opportunity to the employer and employee to adduce evidence before it. It is open to the employer to adduce evidence for the first time justifying his action, and it is open to the employee to adduce evidence, both of them. Now, kindly see serial number 7. That's what I want to say to your lordships, my lord. Serial number 7.
Okay.
Serial number 7, my lord, kindly see. Let me read. It has never been
Read 8.
Yes, that an employer who wants to avail himself of the opportunity to adduce evidence for the first time before the trial could justify his action should ask for it at the appropriate stage. This is what my question is,
That
my
is
lord.
the problem. That
No.
appropriate stage.
That's what. Now see, that stage, when lordship will hold it, because nowhere is written. Suppose the court held that your inquiry is defective. I'm fixing another date. In that date, if I had not made any prayer, yes, my otherwise, how do I know, my
No,
lord?
in one decision, that appropriate stage was decided. Let's see how many judges was that. Because now we know Karnataka is probably I can help you from
Five
Karnataka.
judges bench that is.
But before that, let me see what
Yes,
the other case
definitely.
where this appropriate thing was mentioned in one
Because
case.
this is the judgment where, my lord, on this point, there is no clear-cut judgment.
There is one appropriate stage has been mentioned in one case.
My lord. And 7 is really clear. In one shot, tribal level court cannot do all these things together.
No, that is okay. We are, you have done, it looks like you and your entire team has burned a lot of
No,
midnight
my lord.
oil.
Actually, what happens, my lord? I feel when lordship said that, I enjoy doing that, my disturb homework, my lord. Research side work, I enjoy, my lord. That's my nature, actually. With my team, I enjoy that. In any case, my lord, I try my
It's
best.
always, I remember those days when, to find those answers, sometimes you forget to sleep and eat also. But when you find it, that pleasure,
I get it, pressure, my lord.
that is different.
Yes, most of the day, my lord. Yet 12 I send him, my lord, my lord, and spend many decisions, my lord. In fire extinction case also, it was demanded back by.
One second. In Cooper also they have said something about request stage.
Cooper, yes, Cooper is there.
Cooper,
Now, that I have given, my lord,
yes.
serial number 1, first day I have given the punch,
Cooper.
serial number 1. Cooper.
Serial number 1 is Cooper.
Cooper, yes. Question put on paragraph 5, my lord. Cooper, paragraph 5.
Paragraph 5.
Yes. There are other also, but let us see that paragraph 5.
No, that appropriate stage has been mentioned.
Oh, no, not
I think it is there somewhere in Cooper.
Cooper net stage to type marathon. Yes, it is marathon. Cooper. Beside this also, in the Cooper case, my lord, it has been workman mature case has been recorded, and it says that is why this court has consistently held that if domestic inquiry is irregular, invalid, or improper, tribunal may give an opportunity to the employer to prove, my lord. Now, conjoint treating looks like their appropriate.
Yes, I think Cooper will be of help to you.
Yes.
Let's read para 22 of Cooper.
Yeah, that I marked the other day. I read it, my lord.
Just read.
We are therefore clearly of the opinion that when a case of dismissal or discharge of an employee is referred for industrial adjudication, the labor court should first decide the preliminary issue, whether domestic inquiry was violated. The principle of natural justice, when there is no domestic inquiry or defective inquiry is admitted by the employer, there will be no difficulty. But when matter is in controversy between the parties, that question must be decided as a preliminary issue. On that decision being pronounced, it will be for the management to decide whether it will introduce evidence.
So
That's
this
what
is not given to you.
that's what I
This,
said, my lord.
this opportunity was not given.
That's why I said, my lord.
So I think I can,
Yes.
without going further into
Matter.
the depth of the matter,
Yes,
perhaps
yes.
like from
I think so.
Cooper
I think so. I think
at
so.
Karnataka probably.
Yes. No, after my lord.
Because it says, then it says, if it chooses not to adduce any evidence, it will not be thereafter permissible in any proceeding to raise line issue.
It means that day court will say defective,
Correct.
court will fix the date.
Correct.
If I don't do anything.
So here, the court has not given you that time.
No, no. See, because court in one day, that paragraph 7, lordship is in paragraph 7. This 7, 27, 7.
It says on that decision being pronounced. Suppose the court pronounces that the inquiry is bad, then it will be for you to decide whether you want to adduce evidence or not.
Here is
So
the no
you
chance
have
because
just see, Mr. Nath, many a times you say that please give us the liberty to do this after the judgment is pronounced,
yes,
right?
yes.
But, or alternatively, you can also say that, well, in case it goes against me, I may be given. But nonetheless, in your case, the labor court, the moment the labor court has held, before sending it for reinstatement, he should have fixed it on a date, asking you or letting you know the decision of the court.
or fixed for orders for necessary orders.
Correct.
Next
That
day,
date, if you don't ask, then subsequently,
then exactly, absolutely right.
I think I can
Absolutely right. I think
take it in
my
that
lord,
line.
this is 10% right because last all these days, how many lordship has seen, how many judgments I have given? I'm trying to find out there only. The question lordship posed to me, my lord. There, I cannot get answer. Where should I get a chance? Here, 7, 12, 22, we made the argument. 13, 12, 22, entire judgment has been passed. In violation of that paragraph 27, 7. In one day, they finished everything. Patient was admitted, medicine was given, patient died, it was buried, everything was done on that day.
All right. I'm not going to close it, but arguments, I take it as complete. Huh? I'm posting it another date after I return so that I can prepare the judgment.
My lord, this will be a judgment where on this point, my lord, there's no
A little, there's no clarity. So some discussions will have
no,
to
it will
go.
help the future course of action for
Correct.
the courts, my lord.
There's a little bit of a small bit of gray area, which
yes.
needs to be little
My lord.
explained, I think, that part.
My lord.
So some
Then
reading has to be done.
I'm so obliged to your lordship, my
No,
lord.
no.
Because this type of matters, I think this is my second case, my lord. I've never done my lord. Second case. So
We all learn every day.
my lord, that's all. That's the answer.
This is the beauty of our profession. Isn't it?
Profession, yes, my lord. Profession.
Okay. Did saying that pursuant to the Mr. Nath has relied on a series of decisions of the apex court to buttress his point that once the labor court comes to a finding that the inquiry is vitiated, the labor court must give an opportunity to the management to prove its case on merit and cannot straight away, without giving the opportunity, reinstate the workman. Refix on such and such date for further hearing. এইখিনি বেলেগকে দি দিবা এইটো মই এতিয়া চিৰিয়েলটো ঠিক কৰি দিবা লৈ আহিবা ফোনটা ও গড ইয়েছ ওপৰা পৰিলে এইটো চাই ল'ব
Please read one, please, my lord.
Sorry?
We read only one case, but from your lordship side, I always tell them, see every case, my lord, lordship says my mind.
Anyway, we chose it.
Oh, bless my lord.